Welcome to our comprehensive video series on Indian Evidence Act. Indian Evidence Act is a legislation that governs the rules and procedure related to admissibility of evidence. So the primary role of Indian Evidence Act is to ensure fairness in presenting the evidence in the court. Now, how do we ensure fairness in presenting the evidence in the court? Is there any procedure on presenting the evidence in the court? किस तरीके से किसी एक फैक्ट को प्रूव करना है, किस तरीके से एविडेंस अड्यूस करना है, किस तरीके से एविडेंस को प्रेजेंट करना है कोर्ट में, इन सब चीजों के बारे में इंडियन एविडेंस एक्ट हमें बताता है. इन दिस वीडियो आई विल बी शेयरिंग द बेसिक स्ट्रक्चर ऑफ इंडियन एविडेंस एक्ट, एंड इन द नेक्स्ट वीडियो आई विल बी sharing the meaning of fact, relevant fact, and fact and issue. So do not forget to subscribe to my YouTube channel, like and share my video if you find the video to be valuable and informative. So let's start with an example that A has a cause of action against B. Now, if A has a cause of action against B, he will file a suit. And for filing a suit, if it is a civil cause of action, he will file a plaint. Plaint under Order 7 of CPC. And in the plaint, he will allege certain facts. After the drafting of the plaint, he will serve summons to the defendant, that is B. And now B will file a reply to the plaint. Let's draft it here. Now this is the reply. B, and this is his written statement, and written statement is given under Order 8 of CPC. Order 8 of CPC talks about written statement. Now, when the defendant is going to file a reply to the facts which are being alleged by the plaintiff in his plaint, he will either admit or he will deny, or he will not reply. He will not reply. The defendant, while filing his written statement, must give a para-wise reply. उसको हर एक पैरा का रिप्लाई करना है, और अगर किसी पैरा का उसने रिप्लाई नहीं किया, नॉट रिप्लाइड, या फिर उसने एडमिट किया है किसी भी फैक्ट को, या फिर वो डिनाई करेगा किसी फैक्ट को. So now, the facts which are admitted, हम उनको कहते हैं admitted facts. Admitted facts के ऊपर Section 58 of Indian Evidence Act states that admitted facts need not to be proved. Why it need not to be proved? Because the defendant has already acknowledged, has already admitted those facts. उसपे कोई मुद्दा ही नहीं है. Plaintiff allege कर रहा है और defendant ने उसको admit कर दिया है. So all of you must have a notebook and a pen and your Bare Act and take a lot of notes. So if you open your Bare Act, and go to Section 58 of the Indian Evidence Act. Section 58 of the Indian Evidence Act states, facts admitted need not be proved. Admitted facts को prove करने की जरूरत नहीं है. No facts need to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands. So if they agree to admit by any writing under their hands, like I'm giving an example of written statement, or even if they are admitting at the trial stage or at the stage of proceedings, that is at the time of hearing, or by any rule of pleading in force, underline rule of pleading. What is the rule of pleading? In force at the time they are deemed to have been admitted by their pleadings. So rule of pleadings deemed to have been admitted. Deemed to have been admitted को please underline करो. Deemed to have been admitted मतलब हम presume करेंगे कि वो facts admitted हैं. कौन से facts को हम presume करेंगे जो कि वो admitted हैं? ऐसे facts जिनका defendant ने reply ही नहीं किया है. So these are those facts deemed to have been admitted, to which the defendant does not reply. So basically, Section 58 is stating that any fact which has been admitted by the parties at the time of hearing, or any fact that has been admitted by the party under his hand, or any fact that has been admitted by the party in writing, example I gave you by written statement, or any fact which is through rules of pleadings deemed to be admitted. So as per the rules of pleadings, which are mentioned under Order 6 CPC and Order 8 CPC, it states that any fact to which the defendant does not reply is deemed to have been admitted. We call it as a principle of deemed admission. हम उसको कहते हैं principle of deemed admissions. So going back to our example, the facts which are admitted need not to be proved, and the facts to which he has not replied, those facts also need not to be proved. No reply are deemed admissions. They are deemed admissions. Deemed admissions. Even they need not to be proved. So अब प्रूफ किस चीज को करना है हमें? ऐसे फैक्ट्स जो प्लेंटिफ अलेज कर रहा है और डिफेंडेंट जो है उनको डिनाई करना है. दिस इन फैक्ट्स के ऊपर हम इश्यूज फ्रेम करते हैं. वी फ्रेम इश्यूज ऑन दीज फैक्ट्स. इश्यूज, facts which are alleged by one party and denied by another party. Another party. So इसके ऊपर जो है हम issues frame करते हैं. So issues are framed on facts which are alleged by one party and denied by the other party. अब जो ये इश्यूज हैं, ये इश्यूज भी क्या है? फैक्ट्स ही है. अब प्लेंटिफ को इन इश्यूज को प्रूव करना है. प्लेंटिफ को प्रूव करना है कि जो भी वो फैक्ट्स अलेज कर रहा है, फैक्ट्स अलेज्ड, दे नीड टू बी प्रूव्ड, एंड फैक्ट्स डिनाइड also need to be proved. Also needs to be proved. So facts alleged and also facts denied, they need to be proved by the plaintiff and they need to be proved by the defendant. But how do we prove these facts? And which facts need to be proved? कौन से facts? कैसे? What are the means to prove these facts? और हम कौन से फैक्ट्स प्रूव करेंगे और कौन से फैक्ट्स को प्रूव नहीं करेंगे? सो इंडियन एविडेंस एक्ट जो है, इट इज रिवॉल्विंग अराउंड फैक्ट्स. इंडियन एविडेंस एक्ट हैज 11 चैप्टर्स एंड 167 सेक्शंस. All these chapters and sections mostly are dealing with facts. So the first question is that out of all these facts, जो ये वाले facts हैं, इन सारे फैक्ट्स में से कौन से फैक्ट्स हमें प्रूव करने हैं और कौन से फैक्ट्स हमें प्रूव नहीं करने हैं? सो लेट्स से these are all facts which are being alleged by one party. Now, out of these facts, which facts are to be proved? We say only the relevant facts and the fact in issue. Relevant fact and fact in issue needs to be proved. Out of all these facts, we are not going to prove these facts. We are just going to prove relevant fact and fact in issue. ये कहाँ दिया है? This is given under Chapter 2 of your Indian Evidence Act, starting from Section 6 to 55 of your Indian Evidence Act. Section 6 to 55. So the first question is, what facts need to be proved? So what facts need to be proved? Chapter 2 states that only relevant fact and fact in issue needs to be proved. And relevant fact क्या होते हैं? जो section 6 to 55 में form. So what are the relevant facts and fact in issue? A fact which is being alleged by the plaintiff, if it is falling from section 6 to 55, उसको हम प्रूव करेंगे. अगर एक फैक्ट सेक्शन 6 to 55 में फॉल नहीं कर रहा है तो हम उसको प्रूव करेंगे नहीं. कोर्ट उसके ऊपर एविडेंस नहीं लेगा. या तो वो फैक्ट रेलेवेंट फैक्ट होना चाहिए या फिर वो फैक्ट फैक्टेड इश्यू होना चाहिए. ईदर ऑफ देम. सेकेंडली, व्हाट फैक्ट्स नीड नॉट टू बी प्रूव्ड? Need not to be proved. जो मैंने ये डायग्राम बनाया था, इसमें से ये कौन से फैक्ट्स हैं जो उनको आपको प्रूव करने की जरूरत नहीं है? Which are those facts which need not? See, these are all facts. ये सारे फैक्ट्स हैं. इनमें से हम सिर्फ रेलेवेंट फैक्ट और फैक्ट इन इश्यू को प्रूव करेंगे. That's why I marked picked. Yes. और कौन से फैक्ट्स हैं जिनको प्रूव करने की जरूरत नहीं है? वो चैप्टर 3 में दिए. और वो कौन से फैक्ट्स हैं? सेक्शन 56, सेक्शन 57 एंड सेक्शन 58. ये फैक्ट्स को आपको प्रूव करने की जरूरत नहीं है. So I'll write it clearly here. Section 58 Indian Evidence Act, Section 57 Indian Evidence Act and Section 56 Indian Evidence Act. ये facts को आपको, even if they are relevant facts, even then you don't have to prove them. You don't have to prove them if they are falling under Section 56, 57, 58. 58 we have already discussed. 58 is talking about admitted facts. It is talking about admitted facts. जो facts party admit कर रही है उनको आपको प्रूव करने की जरूरत नहीं है. सो सेक्शन 56 and 57 talk about judicially noticeable facts. Those facts which are judicially noticeable, जिसका कोर्ट नोटिस लेती है, उन फैक्ट्स को आपको प्रूव करने की जरूरत नहीं है. एंड सेक्शन 58 टॉक्स अबाउट फैक्ट्स व्हिच आर एडमिटेड. सो एडमिटेड फैक्ट्स. एडमिटेड फैक्ट्स आल्सो नीड नॉट टू बी प्रूव्ड. एंड चैप्टर 3 में फॉल करता है आपका ये. और चैप्टर 3 में सिर्फ 3 ही सेक्शंस हैं. Section 56, 57, 58. So now we are very clear that what facts need to be proved, what facts need not to be proved. Now the third question that comes up is that the facts which need to be proved, but how do we prove those facts? What are the means to prove those facts? What are the means to prove फैक्ट्स? कौन से फैक्ट्स है ये? कौन से फैक्ट्स को हमें प्रूव करना है? रेलेवेंट फैक्ट एंड factination. So what are the means to prove these facts? The means are, we are going to prove these facts by evidence. We are going to prove it by evidence. Or we are going to prove these facts otherwise. So how do we prove these facts by evidence? As per the Indian Evidence Act, the term evidence is defined under Section 3. And evidence means oral evidence or documentary evidence. Documentary evidence includes electronic records. Electronic records. और ओरल एविडेंस क्या होता है? जो विटनेसेस कोर्ट में आके देते हैं। ओरल एविडेंस के बारे में चैप्टर 4 में दिया गया। डॉक्यूमेंट्री एविडेंस चैप्टर 5 and chapter 6 of the Indian Evidence Act talks about documentary evidence. So oral evidence is given by the witnesses. And about witnesses, we see that we have chapter 9. कौन विटनेस हो सकता है? क्या एक बच्चा विटनेस बन सकता है? क्या एक डम कोर्ट में आके एविडेंस दे सकता है? Can he be a witness? Who is a competent witness? So all that is given under chapter 9. And how do we examine these witnesses? That is given under chapter 10. Examination of witnesses. And finally, किसके ऊपर burden of proof होगा? To prove, BOP. That is chapter 7. So chapter 4, chapter 9, chapter 10, chapter 7, इन सब को मिलाकर जो है, अगर हम इन सब के साथ हमें comprehensive answer लिख पाएंगे in case of oral evidence, but it will depend upon what the question is. So chapter 4 is dealing with oral evidence. Chapter 9, witnesses. Chapter 10, examination of witnesses. And burden of proof means like the initial burden is constant on the person who moves the court. It's the plaintiff or the prosecution. उसके बाद जो onus है वो shift करता रहता है. तो उस कैसे shift करता है, किस पार्टी के ऊपर कितना onus है, वो chapter 7 में दिया. Now, if I want to prove a fact, let's say by getting some material thing in the court. For example, by producing the weapon. Example, I want to produce some mobile phone or some SIM card. In that case, it is neither an oral evidence nor a documentary evidence. उस केस में हम उस fact को कैसे prove कर सकते हैं? Otherwise. That means by real evidence. The term real evidence is not used in Indian Evidence Act, but we derive it from section 60 proviso. And we say that all these material things can be produced before the court under proviso to section 60. So let's read the proviso to section 60. Clearly states that all those material things which are required by the court for its inspection and to prove a particular fact can be produced under proviso to section 60. And we termed it as a real evidence. So if you want to prove a fact, we may prove a fact by evidence or otherwise. And by evidence, when I say, it is going to be either oral evidence or the documentary evidence. Oral evidence, we have chapter 4, documentary is chapter 5 and 6 or otherwise. Now we are left with only 2 chapters under the Indian Evidence Act. That is chapter 8, which talks about rules of estoppel. It is an independent chapter which gives you the complete rules of estoppel. Estoppel is rule of evidence and it is covered under chapter 8 and a very important concept for your mains examination. And generally, even you're asked in your preliminary examination that what is the section dealing with estoppel. So it is section 115 of the Indian Evidence Act. And lastly, we have chapter 11, because in between के जो chapters हैं वो हम ऊपर cover कर चुके हैं. That is chapter 9, 9 is dealing with witnesses, and जो 10 है it is dealing with examination of those witnesses. And chapter 11 जो है वो बात करता है improper admissions and rejection of evidence. Improper admission and rejection of evidence. So जो chapter 11 है इसमें सिर्फ और सिर्फ एक ही section है. That is the last section, and that is section 167 of your Indian Evidence Act. So basically section 167 of the Indian Evidence Act states कि अगर कोर्ट ने किसी एक एडमिशन को इम्प्रॉपरली लिया है या फिर किसी एक एविडेंस को जो कि एडमिसिबल था उसको रिजेक्ट कर दिया है, पार्टी कैन नॉट इनिशिएट अ फ्रेश सूट और अ फ्रेश ट्रायल ऑन दीज ग्राउंड्स. इन ग्राउंड्स के ऊपर, किन ग्राउंड्स के ऊपर? इम्प्रॉपर एडमिशन, रिजेक्शन ऑफ एविडेंस. Party cannot initiate new trial. So these are the 11 chapters of Indian Evidence Act. Chapter 1 जो है, that is an introductory chapter which has section 1 which is dealing with the applicability and scope of the Indian Evidence Act and is equally important for your mains examination because it is in detail mentioning कि Indian Evidence Act जो है वो किसके ऊपर अप्लाई करता है और किसके ऊपर अप्लाई नहीं करता है. Chapter 1, Section 2 has been repealed and Section 3 has all the important definitions which are important for pre and mains both. They are like the term fact has been defined under Section 3, and then we have Section 4 which is talking about may presume, shall presume, conclusive proof. इन सबको जो है आपका Section 4 define कर रहे हैं. So आपका Chapter 1 is having 4 sections. And all those sections are the introductory and they are defining the terms which are used under Indian Evidence Act. Now, we have understood that the facts which are either relevant facts or facts which are fact in issue, इन्हीं facts को हमने prove करना है. और हम कैसे prove करेंगे इन facts को? By evidence. और वो कौन से एविडेंस है? They are going to be proved by either oral evidence or documentary evidence, right? Document. So once we have proved a relevant fact, we call it duly proved. And a fact which is duly proved is admissible. And the judgment is based upon the duly proved admissible facts. ये कहाँ दिया है? This is given under Section 165 proviso Indian Evidence Act. A fact which is a relevant fact and has been proved by evidence, हम उस fact को कहते हैं कि वो fact duly proved है. और जो duly proved facts होते हैं उनको हम उन्हीं के ऊपर जो है the judgment is based. All right. Now this concept of admissibility is again an important concept for your pre and mainly for mains examination. Admissibility is of facts या फिर admissibility of evidence. So do not forget to subscribe to our YouTube channel so that you get the notification on the next video of Indian Evidence Act. And if you found this video to be valuable and informative, please do like and share. Thank you.